Good morning. Are you Eric Segrist?
Yes, ma'am.
And Mr. Segrist is charged in cause number 25, DCCR 1836, with burglary of a habitation. Mr. Lewis has filed a motion asking that I reduce the bond, which is currently set at $50,000. Mr. Lewis, you may proceed. Mr. Segrist, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Go ahead, Mr. Lewis.
Mr. Segrist, will you state your full name for the record?
Eric Martin Segrist Jr.
Okay. At the time that you were arrested, were you employed at that time?
I actually I had a job interview for Walmart the next day, and I missed it.
But you, at that time, you weren't working?
No, sir.
Okay. No, sir. Up until the time that you were arrested, were you able to have any money saved or anything like that that you could use?
Good morning, Mark Garcia, court number 25 DCR 0120. Today, your truth is being tested. You said you did not steal anything, but evidence says otherwise. Now is the time to admit everything clearly.
To hold your bond?
No, sir. My sister was planning on helping me out.
Okay. So any help would come from your family? My family, yes, sir. Okay. Now, the employment opportunity that you did speak of, is that still available to you?
Yeah, as soon as I go home. She actually asked about me yesterday morning.
Oh.
And I have a neighbor in my neighborhood, and she has like a bunch of overgrown trees, and she was asking my sister if I could come over there and clear out all the stuff, and she was going to pay me to help bond out.
And if you're able to make bond, where would you be living?
At 6161 House Street in Groves, Texas.
Okay. Now, is that the same residence as the complainant in this case?
No. That's my sister.
You were found with copper tools and stolen material in your truck, yet you claimed innocence. The judge is not convinced. Your words are conflicting, and your past crimes make things even worse.
His house.
Okay. So you will be able to handle any type of bond conditions, for example, like no contact with the victim, things of that nature?
Absolutely. And the job is walking distance from my house. Like it'll take me 20 minutes to walk there, my house. And I just bought a brand new bicycle, so I could ride my bike straight to Walmart to go to work.
Okay. Now, as far as the bond amount, it's currently set at $50,000. About how much do you think your family could afford? We could afford to try to help bond you out?
Well, I'd say, because I have another bond that's $10,000, and so probably around that area, so she can get a better deal with the bondsman, like around $10,000.
So you're asking for a bond who says $10,000 on this case, but ultimately you would have a bond option.
5 prior felony convictions already on your record. Still, you stand here repeating the same mistakes. This is not your first time, and the court is losing patience with your behavior.
You gave some approximately $20,000.
Yes, sir.
What's the other bond for?
It's for an assault case, I believe, Judge.
The misdemeanor assault.
Misdemeanor assault case.
Any questions?
No questions, Judge.
Any other witnesses?
Oh, no, Judge.
All right, Mr. Smith, what is the state's position?
Judge, this was a case where he broke into this house, sliced his arm very badly on the window, trying to break through the window, assaulted the victim in the case, stole her phone, and ran away after the police had been called. They were able to find him because they used to track my iPhone. It's family violence. They were living together at the time.
The judge rejects the 16-month deal, saying it is too lenient for someone with repeated crimes. You could be facing 2 to 10 years. This decision shocks the courtroom completely.
We have had contact with her. She came in and talked to me last week, or before last, on this, so we would be opposed to a bond eviction.
And just for the record, I'm taking judicial notice of the court's file. It does include the probable cause affidavit, and so I have reviewed that as well. Anything else, Mr. Lewis?
Well, Judge, This is the one that we, of course, reset from recently when the state was looking to hear from the complainant in this matter. And I think, like Mr. Smith said, they did have a chance to talk to her. And even from my understanding from that conversation of what we're dealing with is a situation where it's still kind of shaky as far as factually of what went on between him and her that evening. It is something that he definitely wants to pursue. I'm not just going to say a trial.
Next case, Eric C. requests bond reduction, claiming he has a job opportunity and family support, but the charges against him are serious, involving violence and burglary.
But to pursue this matter further as far as trying to get it resolved, he does have plans to hire his own attorney, who's Mr. Parker. He's gone now, but that's initially who was the family's going to try to help hire for him. So they're looking to bond him out and hire his own attorney as they proceed with this matter. We're just asking for him to have that opportunity. That way he can get back to work and help pay for that on his own and not be situated with any burden obligation on his family moving forward.
Okay, at this time, taking into consideration the factors in Art 17.15, I am going to find that it is not in the best interest to grant the motion to reduce the bond. I'm going to deny that. The underlying fact.
The prosecution reveals he broke into a house, injured himself, assaulted the victim, and stole her phone. The evidence is strong, and the victim has already spoken against him.
The testimony today, and so what we'll do is get it set as quickly as possible. If the family hires Mr. Parker, great. If not, then Mr. Lewis obviously will remain as your attorney and move forward with going through discovery, and we'll get it set for an announcement and move forward as however you guys plan to at that time. Okay. Go back with the bailiff. Good morning. Are you Kenneth Bartol?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
Your Honor.
I am going to first also, I think we've probably done it, but just to make it clear, I'll take judicial notice of the court's file in each of the cases. Mr. Barthol was evaluated by Dr. Capon for competency to stand trial, and we received an evaluation and report.
The judge denies the bond reduction, stating public safety comes first. Eric must remain in custody as the case moves forward towards trial without any relief.
Back November 3rd of 2025, the finding in that is that Mr. Barthol was competent to stand trial. Is there any other evidence with regard to competency today?
No, Your Honor. No, Your Honor.
All right, then based on that, I will find that Mr. Barthol is competent to stand trial and proceed. So, Mr. Barthol, in cause number 25, DCCR 1207, you're charged with a third-degree felony offense of obstruction or retaliation from July 19th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Mm-hmm.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in cause number 25, DCCR, that's a state trial. We're going on.
Final case ends with guilty pleas. Multiple charges lead to prison sentences running together 5 years term and 1 year state jail, showing how serious repeated crimes can become.
Count one only in the state jail case.
So is that
1752.
Yes, Your Honor.
Give me just a minute. In 25 DCCR 1752, the state has elected to proceed on count one only. It alleges you committed the state jail felony offense of possession of a controlled substance from January 11th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.